All right, everybody. Well, hey, good morning, good afternoon, good evening from wherever in the world you are joining us live on the Monday Note. We always have a good group of international folks. We are doing some research yesterday and realized we're now expanded to 24 countries out there with people watching this either live or via replay. And so excited. Once again, it's the Monday Note, everybody. We got a lot of requests for the topic on a nice thing over the last few weeks. Really excited about our special guest. But before we dive into that, just kind of want to go through the usual 411 for those that are joining us for the first time. I know we usually get quite a few new responders joining us there from different meetup groups across the country, but these are being recorded. We are recording it right now, and so we like to share that. As always, if you want to connect with me online to get access to a lot of stuff, we do a lot of social media at LinkedIn, Facebook, a whole variety of different things, whether it's Instagram, Google+, or Twitter. You can find us there by looking for the handle One Scott Carson or at One Scott Carson. And then for our videos online, you can usually find us by searching on YouTube or Vimeo at We Close Notes. Now, we upload these recordings to straight direct to Vimeo, and then we upload them later on to YouTube as well for you guys. But really appreciate all the positive comments, the feedback, the likes, the shares that you guys are doing with these replays. I know that you guys appreciate it because you get to go back and catch the information. If you've got to step away for a minute or two or can't make it, there's the chance for you to be able to catch them. So it was interesting. I literally find out that over the last 12 months, most of our Monday Notes have averaged double the downloads or people watched them within 3 days after we actually roll these out. So it's kind of interesting seeing the demographics and the states that people are watching along with the different countries. So we do a couple upcoming events just to briefly discuss with you guys. Before we do that, we got people that are new on the call here tonight. So we have a lot of people that also are experienced note investors. We have a lot of experienced real estate investors on the call. We also have people that are looking to dive into real estate investing, note investing. And so we always encourage you guys to ask questions about the topic at hand. If you've got an outside question that's not exactly a right-on task with what the topic is, and maybe it's a little bit different than what the main topic is, just say that to later. We'll leave it open for plenty of opportunity for you guys to ask questions. But our next virtual note buying for dummies workshop, we've had several people ask about that, is March 11th through the 13th. That's literally just a few weeks away. Really amazed at the huge turnout we had 2 weeks ago with 175, 180 actual investors join us for 3 days of information. Prior to that, they'll be up in Portland, Oregon, actually, on March 8th, speaking at one of the RIA groups up there. I want to thank Cody Cox for helping putting that together. We just reserved RSVP to the hotel today and the meeting space and things like that, so we're really excited about that. If you can't make it to those, or you've been through one of the workshops, or really looking for something to kind of kickstart, or somebody to give you a nice swift kick in the ass with your note investing, we always have our fast track note training, which is kind of our 101 private, 6 to 8 investor events there. Our next one will be March 24th through the 26th. That's actually a Thursday, Friday, Saturday, because I believe Easter is the 27th. So you come in and spend 3 days with us here in Austin, Texas, and we'll really kind of kick you out the door, get you rocking and rolling. So excited. The last few people that were there in January, Timmy Abney is going to be closing on 3 deals. She got 14 approved. Her first 14 bids were accepted, but after we did some due diligence, we've narrowed it down to 3 that are going to be some really nice stuff. Gary Nash, who was there as well, has gotten several banks to send them their profiles and NDAs he's filling out to get accepted with some of those. Just really impressed with the group that's really doing some stuff there that came through that. So that might be something for you. If you're interested in learn more information about those, feel free just to drop me an email. What did you come in the middle of? Phyllis, I don't know what you registered for, but this is an asset. Monday Notes conference call. We'll talk about asset protection here in a little bit. But literally, those are the upcoming events for you guys. We do have our next Note Mastermind, April 15th to the 17th in Austin, Texas. For those of you guys who are, Wednesday rolls around, kind of a hump day, have a hard time giving it the hump. We actually have something kind of cool that myself and George Antone are going to be doing this Wednesday. We're going to have a hump day happy hour basically at 5 o'clock Central Time. Be sharing information on Facebook for you guys, just kind of spend an hour going through what's going on in the market. George Antone is the author of the Banker's Code. It's the second edition he's had at the most powerful wealth building strategies found and revealed, which is very important for what we talk about later tonight. But George's an author of that, buddy of mine, one probably the nation's best at helping investors raise private capital for the real estate deals and things like that. But he's out of Sacramento, California as well. We'll be doing kind of a hangout at 5 o'clock Central Time on Wednesday. So stay tuned to Facebook for that information. As always, guys, we're looking to network with other note investors. We have a wealth of note meetup groups across the country. Michelle, congratulations. A couple offices. Phyllis is cracking up at the music I had. She wasn't expecting Frank Sinatra tonight. That's funny. We just have uploaded a couple for those of you that are in California. We've expanded into, obviously, the Golden Bear State, San Francisco Bay Area, Orange County, and then the Los Angeles area as well. So if you're interested, go to meetup.com and you look for the note closer groups in those areas. We opened them up like last week. We've had 70 people join the San Francisco group, and I think Orange County and LA are both right at 50. So excited the advancement of those groups gives you the opportunity to network with local investors there. I know that Steve Stroud is kind of putting together the San Francisco one. He'll be looking to have a live event, a networking event here in the next few weeks. And then Jay Tenenbaum and Isabella McBride with Amina Capital, a couple of our mastermind students, are also putting together the Orange County and the LA one. So if you have any questions about that, feel free to contact me. If there's not an existing note closures group in your area, let us know, and we'll see about possibly getting one started there for you guys to network with local investors looking to, invest in notes or maybe even looking for a place to put their money into deals. So any questions about those items before we dive into our main subject tonight, everybody? Give you guys a chance to write your stuff there. Congratulations to Rick and Michelle Hill. You'll think you got a couple deals accepted. That's phenomenal. Glad to hear it. They spent an hour and a half with me here in the office this last week on Monday going through some deals. It was actually Monday, President's Day. Man, boy, the week sure does fly by. So, all right, well, there's no existing questions with those items. We'll dive right into our basic information here we cover you guys tonight. I know a lot of you are excited. We have over 200 plus people RSVP for the webinar tonight. Just excited. Obviously, yes, guys, I want you guys to be a note investor. That's what we focus on. But one of the most important things you do that a lot of just entrepreneurs don't do successfully, don't do it the right ways. They don't set up really the proper walls around their assets. They don't set up the right type of entities. Or maybe they set up an entity in an LLC or a DBA or an S Corp. They don't really know how that figures in with the rest of their information. That's why I'm really excited for tonight's guest. Our special guest tonight, known for a little while now. Actually, heard him speak a while back, and then we reconnected recently at one of Aaron Young's events up in Lake Tahoe a few months back. And myself and then my VP of Operations, Stephanie Goodman, were just blown away at what Kevin teaches and was talking about. We're like, we got to have him on. We got to have him either come to an event or do a webinar with him and really share the wealth of knowledge, because especially in our mastermind groups, the people we talk about, hey, how are you structured? What's the best way to structure it? Which way should I go? And a lot of people don't understand it, and it's different than just going, like I said, going out and creating an entity. But our special guest, Kevin Day, he's the author of 5. There's a smiling mug there for you guys. He's the author of 5 asset protection books and 5 audio courses. And to give you an idea on some of the topics that Kevin's an expert is lawsuits, taxes, and asset protection. He's also authored Offshore Money Strategies, The Privacy Guide, and The Ultra Privacy Guide are some of his books you can find. Found several of them on Amazon.com for you guys, and then also some of his audio courses I think are going to drive home some of the fun stuff he'll be sharing with us. Offshore tax havens, international asset protection trusts, golden parachutes for business owners, offshore money strategies, and how to disinherit Uncle Sam. So let's put our hands together, get excited. I'm sure you want to grab a piece of paper and a pen, pencil, because you're going to take plenty of notes. Let's give it up for our buddy Kevin Day. Hey, Kevin, how's it going, bud?
Hey, really good, loving it.
You had a busy Monday, and I know you were busy this weekend running around getting stuff done too, but we're really excited to have you on tonight. And I'm going to actually close my webcam down so I'm not distracting anybody, because I know people are going to want to take a ton of notes on what Kevin's going to share with us tonight. So Guys and gals, and Kevin and I were talking earlier, if you have questions regarding what he's talking about and the subject matter, it's okay to go ahead and ask those. I'll be watching for those questions and asking to interrupt them as we go. Like I said, if it's a question that's off topic, not exactly on, wait till the end because he'll have an opportunity to answer specific questions that may not specifically hit what he covers on the slide. So, Kevin, thanks, man, for taking time out of your busy schedule. I know it's you've got kids out there in wonderful sunny Southern California to get home to, but thanks for taking time to hang with us.
Oh, no, absolutely. I really love what I do. I think that although our legal system has some fantastic things in it from a worldwide perspective, there's a lot of messed up things that come out of the court despite the facts and despite the law. So what we need to do as entrepreneurs, business owners, is use the law to the best extent possible to counterbalance these weird things where the burglar admits that he was there to burglarize your house, but because you put the glass coffee table under the skylight, he gets $3 million. It's just outrageous stuff that occurs. So we need to learn and know what tools are out there, and getting an idea of the scope of things and what's available. There isn't one size fits all, but you need to know kind of the general options out there, so then you can go, hey, Kevin, I need your legal services right now, or 3 years from now you go, what was that guy that Scott had? I better give Scott a call and get back to that lawyer because there's something that I remember that I need now because of my changes in circumstances. So with that, I think we'll run right into this. Legal disclaimer, I might be saying something that sounds, hey, that's me, and you run off and do it, but if we had a face-to-face conversation, you might give me facts that would lead to a different thing, so this is educational in nature. Now, what most people don't actually do realize, but from a different perspective, that lawsuit protection, real lawsuit protection in the U.S. legal system and most other countries, it boils down to ownership. It has nothing to do with control. And entrepreneurs, even if they haven't studied a lot of business or got an MBA under their belt, they somehow from the vapors remember Rockefeller's last official interview. One of the questions that he was asked, it was in the last official interview before he died, was, hey, looking back on your long life, what was the formula of your success? And he said, own nothing and control everything. Mm-hmm. So when I say, which we're ultimately going to get in here, change ownership, I'm going to take ownership away from you, but I'm going to let you control it. You'll have the checkbooks, you get to make all the decisions of how investments go, etc. They'll say, oh, great, sign me up. If I say, I want to take away ownership and I want to take the checkbook away from you, they say, get out of my office. So we know how entrepreneurs think, and we can get the job done for you. And a change of ownership doesn't mean, oh, let's put it in my brother's name or sister's name because they don't have tenants, they don't have investments, they don't have employees. That's the wrong idea, although it sometimes works, but their nasty divorce, their freak car accident can take your retirement. And these are people you love. They're the last person on the planet that you want to be angry with, because they, even though you have the higher profile, their accident takes your retirement. Also, if it's really truly worth protecting, there's tax consequences of shifting these things around, and that's where trusts come in. So we're going to talk about trusts because they are a change of ownership. I'll be talking about why. And there's all sorts of trusts. offshore trusts, domestic trusts, we have them all the way up at $48,000. We have them all the way down to $2,000. Different trusts for different jobs or different budgets. It might be, hey, I've got high liability. I need an offshore trust, but it's not appropriate for your budget. What is appropriate for you, and what can we use as a stepping stone mechanism to really give you protection? I'm also going to talk about privacy companies. You mentioned my very, very, very good friend, Aaron Young and Laughlin. Privacy companies are very critical because of that ownership and control. None of our clients, or very few of them, we have a few with circumstances that require them not to be in control, but most entrepreneurs want and need to be in control. And if we're taking ownership away at the trust level, we need to give them back control. And the way to do that is with underlying companies. Being the manager of an LLC and having the checkbook and the fact that you used to own it and this is part of your estate plan does not amount to ownership. If the trust is the owner, not only does it give you true lawsuit protection, but it also gives you legal deniability under penalty of perjury. Do you own Golden Mountain Funding of Nevada? And you're able to say no because legally you're not the owner. So privacy companies are really important in playing the litigation game, and so you need to know a little bit about those. Now, what is a trust? There's my two little kids, but they're not so little anymore. The original owner, we're going to call a settlor, sometimes called a grantor. The settlor sets up the trust. They're the person that used to have the ownership, and they're going to give it away. And this format works whether it's a simple revocable living trust, which I hope everybody has. If they don't, give me a call or we'll have another session with Scott and tell you about why you want your basic estate planning. But this presentation is protecting your assets, and that means from a big event that you don't want to happen. We all know we're on the conveyor belt to death, so we do need to get those affairs in order at some point, and my law firm can do that no matter what state you're in. But from a lawsuit protection point of view, it's the same structure. We're creating a trust document called a trust deed. Lawyers will sometimes use that. It only has held on in the real estate arena, as you know, but it's a contract. And you split the ownership between beneficial owners and legal owners. And the irrevocable version of these things, there are trusts now, starting in 1988 in the United States, where you can name yourself as the beneficiary. But if you name yourself as the trustee, then you're not going to have lawsuit protection. And as I said, there's a variety of trusts. We want to pick the right one for you, and we're going to talk about some of the highlights. Now, the big question, if ownership is not being the owner is the key to real lawsuit protection, we need to know what can own things. And essentially, there's 5 things. We've got the business entities, corporations, LLCs, limited partnerships. We have humans, you can own things, and trust can own things. The first 3 that I mentioned, corporations, LLCs, and limited partnerships, they are not ultimate owners. They can own things like a human. They can enter into contracts like a human, but they have to have a member or shareholder or partner. And so when it comes to, and then obviously humans are the benchmark, and nobody owns a human. And so they're an ultimate owner. So a corp can be owned by an LLC that's owned by an FLP that's owned by a triple LP that's owned by a corp. Ultimately, if it hits a human, that's the end of the line. So that's an ultimate owner. The other thing is a trust. Now, a revocable trust means that it can be shut down or the benefits can come back to the original owner. So they are not lawsuit proof and they're not an ultimate owner. But irrevocable trusts are ultimate owners, and that's going to be our playing field. So we only have 2 ultimate owners in our legal system. Flesh and blood human is an ultimate owner. There's nobody that owns you, and nobody owns an irrevocable trust. It is the owner. And so we're going to take advantage of that. The next thing we need to kind of cover before we move on is kind of what can we do? Certainly, you want to set up your lawsuit protective plan when your legal seas are calm, or at least relatively calm. We have contractors, developers, certain physician groups that always have lawsuits going on. It's just the nature of their business. We just have to move ahead. We're not going to sit there like a deer in front of the headlights, and then some mammoth lawsuit comes around the corner 9 months later because we didn't take action, the estate gets wiped out. So we do have ways to proceed with somebody that might have litigation. It's not going to be the silver bullet. We need to make allowances for that current, existing, known creditor, but we don't have to stop and wait for that one that's down the line that we just don't foresee. So pre-liability lawsuit protection is the best, and we have domestic versions as well as offshore versions. Certainly if somebody has a major judgment against them, there are some ways called a fresh start that won't apply to everybody, but some people. Now, hopefully most of you have not gone through a lawsuit, but a few of you, I'm sure, have. And there's also a few of you that haven't directly gone through it, but you've had a friend or a relative that has. And but you need to know about the 5 steps of a lawsuit. The person that's going to sue you is going to analyze the viability of the case, but not only the viability of the case, but whether you have deep pockets and whether it's worth running a case. And they have a long time to do it. They have a statute of limitations period in which to do an analysis on you. So a tort or a car accident is only 1 year, but a breach of contract, that's 4 years. So if somebody feels that they've been misled by you, or they don't like the outcome of their situation and they're trying to blame you and create a malicious lawsuit, they've got 4 years to look at you, look at what assets you have, and decide to bring a lawsuit. You might not even know it. Somebody's looking at you right now. If a contingency fee lawyer is involved, they're looking not only for their clients, but they're a business partner on the lawsuit. So they're looking for their own pocketbook, whether this is a good case to move forward. If somebody is an hourly type lawyer, or they only take cases that are hourly, the good lawyers are still going to do the same analysis for their client's benefit. Also, if they take the case anyway, it's also going to paint the picture on whether they're going to be, I'm going to run, shoot some flares across the bow, see if we can get a settlement, but they don't look like they have a lot of money, so we better take whatever settlement's on the table and get out quick, versus if you look really wealthy and all of your pieces are out on the table, not in privacy companies, why settle? Let's push to the end, and they've got more to lose than we do, so let's blackmail them. Anybody who's been through a lawsuit, that's what it feels like. Once it starts, even though you might know the rationale of why it started, that's the biggest complaint that we have from our clients, that, wow, I know why they started, but why are they doing this, this, and this? It feels like they're blackmailing me. That's exactly our legal system, is try to make you feel that you'll lose 5 times as much in the court case, so you'll give me twice as much as you ever would have rationally thought of giving me because of the little damage that occurs to me. That is our legal system. That's why my job is so important. That's why you have to take action to develop a plan. You might not implement all of it today, but if we have a roadmap of what's perfect for your situation or how your estate and business is growing, then I can give you a roadmap so you build the building blocks in the right fashion, and you're not wasting money or time going down dead ends and have to pitch that and start all over and spend good money again. So the process is they have a lot of time. Once you get sued, you have 30 days to answer. It's a racehorse once the lawsuit occurs. Discovery is really important. Those are interrogatories and depositions. And the biggest question is, do they get to ask you where your assets are and how much are in your bank accounts and what are those notes payable that you have and how much are those worth? Can they ask them in discovery? Yes, but your attorney better be objecting to it. They have to decide on their own during that analysis stage whether you have a lot of money and whether it's deep pockets. So they have to hire investigators. And now, not so long ago, 10 years ago, you had to hire a private investigator. Now there's all kinds of programs that you pay $400 to or whatever, and you can get a lot of information on people. But they have to decide that on their own, whether you're somebody driving a Bentley and have 5 companies and you must have a lot of gold in all those companies, you're going to be worth suing. In discovery, they, except for a few odd types of cases, they only get to ask you what was the duty of care that you had to me? How did you breach the contract? How did you harm me? Did you have a duty of care? And how much was my damages? And how much are you responsible for? Were there any cross complaints that might diminish my cause of action? That's what discovery is about. Not whether you drive a Bentley and live in Rancho Santa Fe or whether you live in Ocean Beach and drive a Pinto and rent. It's about the harm. So part of our structuring with irrevocable lawsuit-proof trust and privacy company is to change the incentive to sue before a suit even starts. And we have absolutely derailed lawsuits. We have prevented lawsuits from occurring. And we know we have gotten people to settle at fraction of the cost because of that picture that we can paint. Trial. Less than 1% of cases go all the way to trial. Because even if you're holding all the aces, weird things happen in court on the plaintiff's side as well. So everybody ultimately wants it to settle before trial. It's whether I can blackmail you and I should blackmail you to the very court steps because I'm going to suck more dollars out of your pocketbook, or whether I should settle early for a little bit because it looks like that's all I can get out of a turnip. And that's part of our planning. Now, once somebody has a judgment, if you don't write a check that day, then you're going to have the collection process. You're going to be called in about 60 days, within 60 days, for what's called a debtor's exam. Now they get to ask you under penalty of perjury. Perjury is a felony. Lying to the court is a felony. That's not a good idea. They're going to ask you under penalty of perjury, how much money do you have in the bank accounts? What are those bank account numbers? How many companies do you have? Do you have any notes payable? Do you have any notes receivable? Does anybody else owe you money? How many cars do you have? How many properties do you have? What companies, whether they're LLCs, limited partnerships, corps, do you have? And they're going to send a marshal out to take those things. And so what we want to do, if we have an ultimate owner other than you, an irrevocable trust, that's not on that list that they ask you under penalty of perjury to list everything you own. If you're not the owner, you don't list those things, even if it's part of your estate plan. So there's a very powerful mechanism in the trust. But one threshold that you need to know before we get there is the difference between attachment orders and charging orders. If I get a judgment against you and I now have the debtor's exam and you list all the assets that you have, if you own things in your own name, I can attach them. I'm going to ask the court for an attachment order to give me your Microsoft stock, to give those notes payable to you, to switch them from your name to my name, to do a judicial foreclosure on properties that you own in your own name. So anything that you own in your own name, I can get an attachment order, a taking order to give to me. That also includes corporations. But limited partnerships that grew out of actually LLCs grew out of limited partnerships. So those two types of business entities came out of a different law than corporate law. And an attachment order won't issue, only a charging order. So that's why real estate investors, whether you're investing directly or through notes, often will use LLCs because you can get the charging order. A charge is a lien. So instead of absolutely taking the assets today, I only get a lien against those assets. That often encourages settlement. Not always, but it's one more tool, one more arrow in our quiver that gives us a better asset protection plan, knowing the difference between these attachment orders and charging orders in the type of company that we're going to recommend for you. So here's my little picture of your world. You own a company, it owns money, you might have customers, you might have employees, you have some real estate, you have your home, which is the green one, you have other investments and so forth. These things ultimately lead to you, and you own them either in fractional interests or whole interests. What occurs, one of the things that we want to do is separate assets. Any of you, I'm sure, if you've gone to a lawyer, whether they're a business lawyer or an estate planning lawyer, and you say, I want lawsuit protection, they're going to say, how many assets do you have? Oh, you've got 3 pieces of real property, you've got all these notes, you've got your home, you've got this, that, and the other. Okay, we're going to give you 5 LLCs. That's putting eggs in different baskets. That's good, but we don't think that that's good enough. It presumes that you'll lose the eggs in any one basket. A boiler blows up in a piece of real estate that's in an LLC. If you've done the LLC properly, it won't come through and take your other properties. It won't take your home. It won't take your bank accounts. But you would lose that property that harmed them. The property in that LLC where the boiler blew up is what harmed them. They're able to take that. We have strategies, particularly that we work with Laughlin with, that can absolutely protect the real property, the different eggs that are in the different baskets. That's taking things to a different level. The other thing that we mentioned at the very beginning is lowering your ownership profile. My law firm does land trusts and those sorts of things, privacy trusts. They certainly lower your profile, but we want to go a step further and give you real lawsuit protection. The next concept that you need to know about protecting your assets is internal liability versus external liability. Now, I already mentioned the internal liability. If you own a company and your employees sue you, or your end users or customers sue you, or your tenants sue you, having that company, in this case I wrote Inc., I probably should use an LLC with the majority of yours investments would be using an LLC most likely. It protects a shield from you, and you've heard the term piercing the corporate veil. If you don't have your paperwork together or you buy your groceries with your corporate card and the other side finds out about it, they're going to be able to pierce the corporate veil. You didn't give your company the respect that you should have, and therefore the court, if you don't treat it with respect, the court doesn't have to treat it with respect, and that means that if the assets of that company are not sufficient to satisfy the creditor, they can come through and take your assets. But if you do the proper paperwork, you don't use corporate assets that are crossing the line. Entrepreneur's job is to live a tax-deductible life, don't get me wrong, but you have to have a reasonable business relationship with why the company card is sending you on that trip to Colorado or wherever. And there's plenty of good business reasons to do that. But there's often business owners that cross the line. You don't want to do it. It's not worth it. Just be creative in your business use, and you'll get a tax-deductible life. But don't cross the line because it does make your company vulnerable. Now, that's internal liability. You will lose the assets in that company, and part of our strategy is making sure the assets that that company uses that has the high liability perhaps isn't in that main operating company. It's in a separate company and licenses it to your operating company, or it rents or leases equipment and things to that other company. Or maybe in the case of notes, the note company, even though notes are actually very low liability, there are some issues when somebody loses a home. They strike out, and if they have some other bucket of money, they sue everybody that touched it, even the low liability note holder. So we want to do is take the money and create a little private lender that's owned by you and your structure, your estate plan, that lends it to the LLC that actually does the note buying. Therefore, if some weird lawsuit hung something, some court says that you're somehow partially responsible, then you're able to say, well, yeah, but I have these pre-existing secured creditors over here with Black Mountain Enterprises in Nevada. You can come and take my company, but they're a senior creditor. You have to pay them off. So there's little strategies that will protect internal liability, and it's easy to do. Now the next question is, what about external liability? Somebody sues you. It's the world that's suing you, not your company. And if they sue you, they get to ask you, what do you own? And that's where we need to decide, when can we use a charging order so that if somebody is suing you, has a judgment against you, and has nothing to do with your business activities, it's because you were in the wrong intersection at the wrong time and the law says you're responsible for it. You don't want to go overboard with insurance. You don't have to hit a bus full of school children to get outside of a $2 million limit. A simple car with 4 people can get you outside of limits. And so what we want to do is not get into astronomical insurance coverage. You want a modicum of insurance. It's always wise. But you don't have to keep up with the Joneses because your estate keeps on getting larger and larger. And so we can create a company that holds your wealth, that pulls money out of your operating company that does notes, and make sure that the note buying company isn't even legally owned by you. So if somebody sues you and they say, oh, you own a Golden Mountain Note Company, you can say, no, I'm just an employee there, and it be the truth. We can make sure an irrevocable trust owns those liquid assets that have low liabilities. If you started to get larger and you started to get employees, then we'll probably put that company in your name. But pull the money out of your investment company into a private lending company that actually would be a secured creditor that is owned by your lawsuit-proof trust. So that's the basic framework. We've got separation of targets by putting eggs in different baskets, but you don't want to get carried away with that, especially if you're in some states like Michigan and New Mexico and California, because it's too expensive to put every single asset into a different company. The taxes are too high, or the operating expenses are too high. Again, that's where customization comes in. Don't underestimate a lower profile on assets, because that analysis stage, what they find in the public record as related to you, the more times your name shows up, the more likely they're going to say, this is a sophisticated business person. They have lots of assets at the end of all those different rainbows. So we definitely want to mix in privacy. Charging orders are very useful with the right assets and the right business circumstances for you. Then the ultimate charge for real lawsuit protection is create a separate owner where you don't have to rely on third parties. We want a closed universe with you and your family, and we can do that through these very old mechanisms called trust. We have domestic irrevocable trust, we have domestic lawsuit protection trust, and we have the international or offshore trust. Now, we've covered a lot of ground. Hopefully that's rung a few bells for you that you didn't know before. My next mad dash is going to be through offshore trusts. One, it's a little bit sexier, so it's a little bit more memorable. Even if the offshore trusts aren't appropriate for your budget right now, we can do domestic versions of this same thing. We can actually, and we do usually, we'll put what are called decanting provisions in the domestic version so you can grow offshore. You don't want to, without that provision, you're typically going to have to take a full disbursement of your assets and refund them into an offshore trust, which starts the statute of limitations clock ticking again. So we want to put a decanting provision in the domestic trust so it goes from trust to trust, so you get the very first trust date as when you gave away ownership. That's very important for those smaller estates that are just getting started. We've got answers for you that will allow you to grow into the future. It's very important. If you have children, we might do very classic trusts here in the United States that are very powerful and work very well. So going back to that concept that our legal system, lawsuit protection is really the concept of ownership, not control. You can have the checkbook. You can make every single decision on what's bought and sold and how much you get paid. But if you're technically not the owner, that's really where you're going to get lawsuit protection. Now, here's a little, for those of you like me that like boxes and arrows, here's a good diagram. And essentially, if you already have a living trust or a will, those would be those things that have high liability or need your name around it. Here I've called it the noisy company. If you're, own a bunch of pieces of property, real estate LLCs there because you are the manager, everybody knows your name is all over it, then you might not be able to hide those. And your personal residence, usually, we need to keep that in your own name or in your revocable living trust because of the special tax treatment, the write-offs, and so forth that you get with your personal residence that you don't get in other pieces of property. But on the right side, we have this privacy company that you can have the checkbook, you would be the manager. We're going to keep your name out of the public record, though, so nobody knows that Black Mountain funding is you. And we can equity strip. We can put senior liens on your home, on your businesses, on your real estate investment companies, and on your note business, so that just like everybody said, do you own your own home? Well, I'm on title, but the bank really owns my home. If there's no equity in an asset, it's not an asset, even if you're on title. So if we can give your own private lending company, Golden Mountain Lending in this example, that's owned by an ultimate owner that's not you, you can literally say to some creditor, hey, yeah, I'm on title to my home, but there's no equity in it. Union Bank is on first, and Golden Mountain Lending is on second. I'm sorry, but you don't have an asset. And these people go away. They really do. In our experience with our clients that have had bad things happen in their lives, 80% of the time, the other side does not see the structuring we've done as related to our client, even though their company, in our example, Golden Mountain Lending, has a deed of trust against their home, a second deed of trust. They don't ask the right questions. They're not expecting small entrepreneurs to use multi-state strategies and structures like this, so they don't even ask the right questions. The 20% that have either known or found out about the structure, not one of them have been pierced. We've gotten very advantageous settlements for our clients. So this kind of planning is very good. Now we have people that have high liability businesses that say, I want very little in my name. I want to lower my profile. And so this configuration is what we would use. We'd still have the privacy company that can encumber your home that probably will stay in your own name. But we can also encumber sister companies. So now, since we've shifted the real estate LLCs over to the lawsuit protective side, we still want to lawsuit proof the equity in those from tenants. So we can still do that even if we shift more assets over to the lawsuit protected side, the irrevocable side. In our last few minutes, I'm going to rush through offshore, why they're so powerful. Really, the cost differences of a plaintiff litigating offshore is a huge one. The law differences are completely different, and the compliance issues. We've had people, I happen to be in Southern California, a little town called Solana Beach. It's in San Diego County. We have a lot of our clients that have properties down in Mexico and in Central South America. And there'll be litigation here, and these are people that have come to us for other issues. We haven't done asset protection planning yet, and somebody gets a judgment and there's not enough assets, and they're down in Mexico. The other side often throws up their hands just because it's not in the U.S. And half of it is they're not licensed down there, so that attorney's job is done. But the big bugaboo that somehow offshore is some kind of buddy system that even if I should, under U.S. NAFTA, U.S. Mexico treaties, be able to get a judgment down there, that's not the general impression, even to lawyers. Most lawyers will just say, oh, you're not going to be able to get it now. And we've had that told to clients on the other side of our clients. And with a little bit of effort, they could have. So just the international card is enough to derail a lawsuit. But certainly the type of planning we would do would really be lawsuit protective, and we'll tell you why in just a moment.
Question for you, Kevin.
Yes.
I'm sure you're going to get to this because Bob asked the question. For offshore companies, where do you suggest setting up the company? And I'm sure it'll depend on what they're looking for, and you're going to probably dive into that in a couple minutes then, correct?
Yeah, we can set them all. Most of the, probably 90% of our clients we're importing foreign law. We're not exporting assets, and probably 90% of our clients. Most of them want the advantage of the Hague Convention, which actually is my next slide, but they want to use a privacy company in the United States. Their investments are here. Mm-hmm. But we do have those clients that want offshore for a whole host of reasons. Either they're investing offshore or they're frightened of U.S. investments. And so we can set up a company almost anywhere. One of my favorites is British Virgin Islands. Some countries like Bahamas or Cayman, they're on blacklists on some other countries. So you want to go invest down in Costa Rica or Mexico, and they say, oh, you've got a Cayman company, you can't invest here because they're on the blacklist of that country's government. And so BVI is British Virgin Islands is a very good country, but we've set them up all over depending on the client's circumstances. So how do offshore trusts work? They work because of the Hague Convention. Up until it started in 1985, we ultimately signed it in 88. The U.S. was the main proponent of it. And before that, to get an irrevocable trust, the only way to get a lawsuit-proof trust was the original owner, mom and dad, to irrevocably give up ownership and control to their children and grandchildren. Classic. I'm using a regular nuclear family example. Well, most entrepreneurs say, well, I don't want to start carving off parts of my estate until I get to about $5 million, which is actually the case. They say, okay, I've got my home and I've got all my goodies and I can retire on this, so this next apartment complex we're going to buy, let's put it in an FLP, we'll control it, but we'll put it into an irrevocable trust for our kids so the equity grows in their name. That's great, but if you're not starting to do that until $5 or $6 million, you want to spend it all on you. You couldn't do that before 1988. So what happened with the Hague Convention on Trust, which as you see from this diagram, most of us know municipal law is superseded by state law, it's superseded by federal law. Most people, even lawyers, say the next thing is the international law in law school is an elective, so they don't know about presidential decrees and treaties and conventions. It's superior to federal law. It's very powerful. And in the Hague Convention, it says essentially U.S. persons can establish trusts in other countries, and that law prevails. Very powerful language at a very high level. Now we can treaty shop. We can shop for the jurisdiction just like we do. Why, do we choose a company in Texas, or do we operate out of a Delaware company or a Nevada company? Because of law differences. We couldn't do that with trust prior to this time. So why is it so important? The first thing for entrepreneurs is that the business owner, our client, can name themselves as the primary beneficiary. That was a huge thing. We have people with $86 million estates that should be carving off parts to the children, and they still say, well, what happens if I want to spend it all on me? I want them to get it at the end of the day, but I want to be assured that I can spend every penny on myself and waste it on myself if I want to. That's kind of an entrepreneur mentality, and so this trust really caught on. We choose jurisdictions that don't recognize foreign judgments, meaning the U.S. judgment is the foreign judgment. We use countries that have complete bar statute of limitations, unlike the U.S. that, it's statute of limitations on fraudulent conveyance, which is the only way to pierce an irrevocable trust here at home or internationally. Here it's typically, 4 years, plus there's all kinds of extensions that our law has eroded to. We want to put redomiciliary clauses in it so it can move jurisdictions. If it's a malicious lawsuit and they're willing to play games, we can play games if we want to. Countries that don't have contingency fee lawyers. We're the only country in the world that is not a loser pays system, which means if you sue somebody and lose, you have to pay all their fees and costs. We're not in a gray area with the IRS. It's not just me saying, hey, this is IRS compliant. We actually have a form, a 3520 and a 3520A, which essentially is a K-1 for offshore trust. This is something we highly recommend. We can do a thing called a hybrid trust, so you don't have to file that, but most of our clients do file it and want to file it. The IRS never became your a better buddy of yours, except in this situation where you get sued. We're able to go into court and say, hey, Your Honor, here's the Hague Convention on Trust, here's all the precedent, it's recognized in all 50 states, and here's our filing with the IRS. They even agree that this is an irrevocable trust under U.S. law. Very powerful. Any trust, whether it's revocable or irrevocable, will avoid probate. That saves a lot of costs and time. We put all your normal estate planning provisions in it. It's a powerful mechanism. So going back to this diagram, whether the trust is offshore or domestic, we would want it to be an irrevocable trust. Working with us, we will select, give you ideas on what different jurisdictions internationally. We work with about 14 different jurisdictions, 8 of them on a very regular basis for offshore trusts. And you just have to remember the problem with success. It's a good problem to have, but now you become a target. Tenants, employees, all those people that yes, see you as being successful, and our legal system encourages lawsuits as a lottery system. Mm-hmm. And people have all kinds of excuse. Oh, they're successful. I'm sure they have insurance, this, that, and the other, and they rationalize why it's okay to try to steal your money.
We just had that, and that's a great example there, Kevin. It happens. I've had, actually in the last 6 months, I've had 2 people try to fraudulently sue me over deals. One that they never got any paperwork on. They were never, no money ever exchanged hands, and they were trying to shake me down for cash. And I had to hire an attorney to go to court twice just to get it kicked out. But it happens. I mean, I had another reason, a JV deal. We followed the letter of the law, and then they wanted to get refinanced out. We refinanced them out, and then suddenly I sold the asset later on for a higher profit, and I'm owed a chunk of that. a lawsuit showed up. And of course, it got kicked out because we followed the T of our agreements. But it does happen, everybody. It does totally happen. And, this is why this is so important. I know we've got some people that are kind of new on, hey, this seems like it's kind of overkill if you're a brand new investor and things like that. It's not. One of the things I think, Kevin, that you talked about when we were in Lake Tahoe was to keep kind of have the end in mind. We all know where we kind of want to go and where we go. And yes, you're not there now, but you want to keep kind of visualize where you want to be and kind of start putting things in place piece by piece by piece as your business, as your profits, as your estate kind of grows, correct?
Absolutely. And part of what we want to do, and I hope I prefaced it well enough at the very beginning, I wanted to talk about the offshore trust as kind of an end game, which some of you are in a position that you should be doing this now. But probably 50% or 60% of you are starting out, and you can't start out with this. You need to use those dollars to buy notes,
right,
and make real estate investments. But we've got those trusts too. We've got $2,000 and $3,000 trusts that still are within U.S. court jurisdiction, but they're an appropriate spending $3,000 or even $5,000 on the right to pick trust is cheap insurance to get something that legally you would have legal deniability over pockets of your money. I mean, it's a no-brainer that we've got little domestic things that are appropriate for those people that are just starting out. But you need to have the roadmap of where you want to build, and do you already have a company in place? And is it an operating company, or is it the stuff that holds assets? And then do you do that next step with a domestic trust, and we put a provision that allow it to go offshore if and when in the future you need to. The sequencing of things, if you're going to do a lawsuit-proof trust now, some little domestic version, let's say, and you're about to start a new business project, we probably want a new, clean company that is formed not by you, but contemporaneously with the trust, so the trust is the original owner. So then you've got a tactical advantage of if they ask you, do you own Golden Mountain Lending that has a lien against your home? And you say no, not always, but the next question might be, have you ever owned it? They're asking the right question for the wrong reason. You're going into deposition and you go, hey, sister of mine, will you buy my company from me, for $100 and I'll buy it back tomorrow, so I'm not the legal owner when I get in there. So they're thinking fraudulent conveyance, not that you put it into an irrevocable trust 4 years ago, but they still ask the question that opens up the can of worms. We'll be able to prove it wasn't fraudulent conveyance. We put it into this lawsuit-proof trust 3 years ago. We didn't enter into a contract with you until 3 months ago. But now you have to spend $20,000 in legal fees explaining why they can't get it. So we, knowing how to set things up and in the right temporal timing order is really important, and we can assist in that. And sometimes you just can't do it in the right order. That's all right. Let's do what we can to give you the best plan. That's what our advice is here for.
Totally agree.
Just for those people that are real fastidious about things, here's a list from what we see. There are different lawsuits. They're little tax havens for different reasons. Some of them are actually high tax jurisdictions but have advantageous treaties with the U.S. Here are the jurisdictions I use for the lawsuit protective trust. I didn't make a list for companies. The companies are actually in different jurisdictions than the companies that have fostered good companies law, or laws that are easy to use, or companies that are good to use when you're a U.S. citizen. But here's the list of those that, for the asset protection trust. Anybody who wants the list for the companies, international companies that we prefer and why, just email me and I'll let you know. Here's the Caribbean, which Bahamas, Turks and Caicos, all of these are countries that most people know, Nevis, Anguilla. They have different advantages and disadvantages for operation. For a trust, we don't like particularly being this close to the U.S. We like using Isle of Man or Cook Islands. If I have an Australian client, I'm not going to put it in the Cook Islands. It's too close emotionally, and we want it to be hard mentally for people to get their heads around. This is where the Isle of Man is one of the biggest geographic tax havens, and it's the oldest one, way before Cayman came on the scene, and it's almost equidistant between Scotland, Ireland, and England. The Channel Islands, Jersey and Guernsey, it's actually English territory, but it's right off the coast of, both of them are right off the coast of France. The Cook Islands is super small. I had to actually use a little highlight to pinpoint that red dot on there. But it doesn't have any bad actors around it. I mean, the Caribbean, everybody's close together. There's a lot of wealth on one jurisdiction, and the country next to them is poor. That adds to duress. New Zealand is, Cook Islands is a New Zealand protectorate, very high education per capita, and there's no bad actors around it. It's a beautiful country, and they have really good tax law. And most of the trustees are British or New Zealand or Australian barristers, lawyers. But getting back to the point, there is a way to create separate ownership from you that's a closed universe that you don't have to rely on third parties. You can be the beneficiary, which means it's all about you, and still give you legal control. And this is kind of the basic configuration. This one is a diagram with a domestic asset protection trust as the owner of this privacy company. If you're just into notes, we would probably make that privacy company the note company, because notes are fairly low liability. If you're mixed, where you have notes and you're investing in real property, this probably is the right diagram, where we would have the real estate property, and it might not be multiple LLCs. It might be one LLC, real estate holding LLC, that has 7 different properties in it. But we could use the notes company, the privacy company, to equity strip those and protect the notes from your personal liability. I think I've actually run a little bit over time, but what other questions do you have?
You're doing fine, buddy. You want to touch base a little bit about equity stripping and kind of what is involved with that real fast? I know that some people are like, oh, am I just over encumbering the property with liens, or am I borrowing against it, or am I taking it all out and having somebody else in somebody else's name, like a second lien against any equity I have? You want to talk about that?
Yeah, that's a good question. If your strategy, which most of your clients are not, but you have a couple that are actually using equity in property to go out and buy notes. So that's going to be a commercial equity stripping. You're going to Union Bank and saying, here's my equity, and please give me some money. Well, if they give you that money, you want to protect that money, and you want to protect the notes, because now if something bad happens, not only somebody coming to take the notes, then you can't pay Union Bank back, in my example, and then they take the real property. So if you go to a commercial lender and you put those liens, so you have no equity in those properties, and you're going to use that money to parlay into better investments like notes, you should probably put that money into a company that's owned by an irrevocable trust, so it's lawsuit-proof.
That makes sense.
And then that company on the right in this picture would make those notes investments. However, if you just have notes and you have other money sources that you've saved up to do the note purchases, what we're talking about is actually equity stripping to your own company. We would make it look like a hard money lender. I think I've used the term Golden Mountain Lending or Black Mountain Funding. That company probably, with the other clients of yours that we worked with is the company that's buying the notes, but it also is the company that puts senior liens on your home and on your investment property that you have. And we actually work with Laughlin to create that paperwork that would put liens. So if somebody is suing you and they see Union Bank on first, and let's say you have a property, I'm just going to pick a number, $600,000, and Union Bank, you have a mortgage of $300,000 on your home, and the other $300,000 is sitting out there bare, and that is going to look real juicy to a predatory lawyer and their client. Well, if Golden Mountain Lending has a second on your home, so Union Bank is on first and Golden Mountain Lending is on second, there's no equity there. Mm-hmm. If they're clever enough to look at Golden Mountain Lending, we want to make sure your name isn't in the public record, and that so they'll have no idea that Golden Mountain Lending is related to you. Often the lawsuit goes away right there. If the lawsuit trundles on and at some point they ask you under penalty of perjury, do you own Golden Mountain Lending? If it's owned by an ultimate owner that's not you, an irrevocable trust, you can say under penalty of perjury, no, I don't own Golden Mountain Lending. And as I said, in real cases, 80% of the time, our clients, plaintiffs, have not seen the structuring we've done, even though they've got the name of their company on a lien registered with the county recorder against their home. They just don't get their arms around it. This is a proper paperwork program, and we have providers for that through Laughlin that will do that. So you don't have the headache. You don't need to know about this. You need to know about it, but you don't have to do it. We have turnkey packages that will do all the documentation, the UCC ones or the second deeds of trust. So you can stick to your knitting and go out there and find more notes. This is a structure, essentially what we want to do. You can't control whether end users or the person that just lost their home that you have some notes on try to wrangle you into a lawsuit, or you have the freaky thing that just comes out of the world. You can't control those, but you can control using the legal system smarter than they want us to use it, so that we can protect everything on the right side of this dual plan. You're going to be out there, you're going to be driving a car, you're going to be talking to people, you're going to make some people envious, and things will happen. Those are out of your control, but we absolutely have ways to outfox the system. And we're not relying on secrets. I shouldn't be telling you things behind closed doors. That's the way I define secrets. If we're doing something behind closed doors that I'd be embarrassed to tell the judge or the other side, and it unravels because I now have told them, that's not a good lawsuit protection plan. But if we can still tell the judge and the other side exactly what we've done, and they still can't get it, that's perfect. But why tell them if we don't have to? As I said earlier, explaining why they can't get it will cost you $20,000 in legal fees. So that's why the privacy component should never be underestimated. It stops lawsuits from even occurring. It's a huge difference. Well, that is the end of my presentation for today. It looks like everybody except for two or three hung in there all the way, even though I went over my time. I hope I've shed some light on how lawsuits work, the game of lawsuits, and that we've got lots of different tools, and we've got fairly inexpensive ways to give you and your family true lawsuit protection and control over your assets. Certainly give us a call if you need to make an appointment. We give free appointments to all of Scott's clients, and we want to get you educated so you know the right next step.
Sure. We got some questions rolling here for you. I had a couple people ask, that I've got a judgment against me from a previous deal, investment deal. Is there a structure that would help me kind of avoid them going after my assets on a previous judgment?
We have to be careful with them. There are ways that we can proceed, but we have to, for lack of a better word, we have to put a chink in the armor in the trust, because it would be a fraudulent conveyance or an avoidable transaction if we changed ownership and did not make allowances for them. Now, that being said, we have had tons of people that have successfully used. We've actually had no one that had problems in doing this. I can give a real example here. Over the last 10 years, with the bank debacle killing our real estate world and mortgages and everything, I've had plenty of people that came to us over the last 10 years that said, I am upside down on these 4 properties. Mm-hmm. I know I'm going to get a deficiency judgment when they foreclose on them, but I own my home free and clear in these other 2 investment properties. I know I'm going to get a deficiency judgment. They're going to steamroll me. Is there anything we can do? And I said, well, we can paint a picture that makes you look different than you are, but we have to put a chink in the armor that if they come all the way, that we don't get you in bigger trouble. Not one of those got to the trust. All of them believed the picture that we painted. And so what we did is said, you need to drag this out for a year or more, and they were able to. And they came on, and then they said, okay, we did judicial foreclosures on the properties, and we have deficiency judgments in all these amounts, and we want you to pay us. And we were able to come back and say, did you look at me? I owe Union Bank all this money, and I own Golden Mountain Funding all this money. I can probably wrangle together from relatives this much if you're willing to settle, but if you're not willing to settle, you go ahead and get a judgment. You're going to have to stand in line. All of them settled. They're not personal creditors, are all angry, and they'll spend all kinds of money. Banks, they're bureaucrats, and they just want to move to the next person that they can fry. They want to move to the next person that has a bunch of equity in their home and fry the pants off of them, and they're happy that they got your $30,000 when the deficiency judgment was $1.5 million. Mm-hmm. So we can't cross the line, but there are things that we can do. There's also a thing that we call the fresh start. I had it in one of the earlier slides. Mm-hmm. And that's if you, we've had clients with great big judgments against them, and they were essentially beat down, but they've got good contacts or good business ideas. What we have to do with the fresh start is actually document that the money isn't coming from you. And it usually involves a gift from a brother or sister, or more likely an advance on inheritance from a parent. And it doesn't have to be huge, but if a parent says, okay, ultimately when we croak, you're going to get $1 million, we're willing to give you $20,000 right now, and we're going to put it in an irrevocable trust for you, and that trust is going to form a company. And we, the people that are starting this, are going to have that company hire you as the manager. This is absolutely lawsuit-proof, with the other side knowing exactly what was done. And we protect the parents or the loving family member that might have helped with this fresh start, because an irrevocable trust, they don't have anything to do with it or any liability with it. Once they sign the trust document, the irrevocability means it's off their shoulders. They don't own it. They don't have anything to do with it anymore. But we can trace back this $20,000 to the advance on inheritance, just like a Kennedy grandchild or a Carnation grandchild with a $6 million judgment against them or $16 million judgment against them. They're living in nice homes and driving nice cars because of trusts like this. We have less zeros behind it, but mm-hmm. You can take that $20,000 and parlay that into something bigger and bigger and bigger just as an employee, and we can regulate how much you get paid. That's very different than your lifestyle. A
Right.
company in the trust can buy your home, can buy your cars, can pay your MasterCard. We literally had a fellow that was an inventor. He had an $8 million judgment against him. He was a brilliant man. He had great contacts. He got a malicious lawsuit from somebody and got this $8 million. And he said, I'll be damned if I'm going to go out and invent new stuff just to pay this guy that absolutely steamrolled me and set me up and take money away for all this effort that should be going to my parents.
Right.
Or to my kids. So we had his actually it was an in-law, give a moderate investment into a trust, a gift into a trust, and had an underlying company. And she said, well, who better than my brilliant inventor R&D son-in-law to make this company grow for my grandchildren? And he worked part-time for the first while. I bet he worked more than that, but he did get a little bit of a salary. And it started rocking and rolling, and the company was making $1 million within the first year and started making a couple million in the years after. And finally the word got out, and the people with the judgment came and did a debtor's exam, and we had to bump his salary up, and we had to bump him up to full-time, and they did get a garnishment on his $80,000 a year salary.
Mm.
But that's not what the company was making.
Right.
So we made it palatable. So have that client give me a call, and I can get more particulars about them, and we might have something that won't be a silver bullet, but will put them in a better position.
That's it. The kind of follow-up question to that, is there a way to protect new deals or new assets if somebody is investing or working with private, other investors to fund deals that can avoid, the judgment coming from them for their profits from these deals?
Yes, we absolutely can structure, when we have an existing issue, we can structure it that it only needs to be quote-unquote vulnerable, perhaps, maybe not, depending on facts and circumstances, to the existing creditor. You have no obligation to leave things vulnerable to new future people that you're entering into contracts with.
Cool. Couple quick questions. What does the MPT stand for in Fresh Start MPT?
Master Protection Trust.
There you go.
It's written a little bit differently than some of the others, yeah.
Cool. Question here. Could Kevin spell the name of the clause that allows a DAPT to go offshore? I didn't understand what he said twice.
Decanting. It's stolen from the wine industry. DECANTING, decanting. And that means that we're pouring all the stuff out of the U.S. trust into the offshore asset protection trust. And this decanting provision we're not just moving the trust, because there's certain provisions that we can't put in a U.S. trust or don't have the power or have some other problem in the U.S. context. So we don't want to just move jurisdictions. We actually want to pour the assets over into a new trust with all these really powerful provisions that do work internationally. So that's why it's called decanting. There's another term that I used, redomiciliary, which means to redomicile, which is a Latin legalese. I try to avoid legalese, sorry. But it just means that we can put it in advance into a trust term, that if somebody, it's a malicious lawsuit, and they do, it's one of those freak circumstances where somebody has too much money and isn't afraid of international, and they do sue in the Isle of Man where we placed your trust, that it has this redomiciling provision that says if you get sued here, the trustees have a right to move it to Bahamas or Cook Islands or someplace else. We've had people that have had suits follow them internationally, and all of them have stood their ground because they said, this is such a ridiculous lawsuit, we're just going to squash it here. But and do away with it. But let's say if it was really a malicious lawsuit, the person has too much money. If they're willing to do that, then you can have the option of playing games with them, and they're going to have to hire a solicitor or a barrister rather in the Isle of Man, and then they'll spend a lot of money and find out, oh, it was moved 6 months ago, and then they go down, where is it now? In Bahamas. Oh, it's been moved from there.
Hot potato.
It's all about keeping options open. It doesn't mean that's what you'll do. It's keeping options open.
Got another couple questions here for you. Is there one of your books that you'd recommend people read to begin with, kind of learn a little bit more about asset protection?
Yes, Lawsuits, Taxes, and Asset Protection is the beginning one. Mm-hmm. And if they buy it from me rather than Amazon, I can give them a 50% discount that Amazon was going to get.
Nice. Cool.
My email is kevin@day-law.com.
Kevin at day-law. We'll be sharing. I'll make sure and pull up your website here in a second, Kevin. So people think. We got a question. Can a personal residence be hidden through a corporate structure?
It can, but there are issues related to taxation. Mm-hmm. But if that is not an issue or not the principal issue, we can absolutely put primary residences in companies. You never want to put real estate in a corporation. You're going to want to use an LLC because of double taxation at the end of the day. So if you're saying having the home and stripping all the equity out to my privacy company and lawsuit protection trust is still too high of a profile. I don't even want to look like I own that house. I want to look like a renter. I want to be able to say I don't own that home. Then we have different entities to do it. And it might be a trust. You usually don't want to get too clever on a revocable living trust, but we could actually have an irrevocable trust that would maintain the tax write-off status of a personal residence. So it wouldn't be in an underlying company. We'd have to go directly to a trust. But we can call that the Johnson Family Trust when your name is Kevin Day. So it paints the picture of exactly what you want to be able to say. No, I'm a renter. I rent from the Johnsons. I rent from the Johnson Family Trust, at least. We don't want to lie. I mean, part of what the skills of a lawyer is to not lie, but paint a picture that leads the other side to a conclusion that we want them to come to that isn't necessarily what's really there.
That makes sense. A couple quick questions here before we wrap up. We got a question here for Bob. If I only loan money to someone who uses the money to buy real estate, so they're basically the private lender to buy real estate notes or property in their name or company name, what protective devices should I have?
Oh, you want to be a secured creditor because just like the bank, just like you want your privacy company, Golden Mountain Lending, to be a secured creditor, not just a creditor, because if somebody files bankruptcy, you can't put liens against people's property at that point. If they're forced into bankruptcy, the bankruptcy court says you weren't secured or you did it at the 11th hour. That's preferential treatment. That happens all the time. Oh, well, I paid my dad off because he gave me $200,000 to start my business 10 years ago. Dad should have been a secured creditor because now Dad is lumped in with everybody else. The bankruptcy court will take that money back away from Dad and say, you're just a creditor like everybody else, and everybody's just getting 60%, not 100%. But if you're a secured creditor, you get paid all that security before all the unsecured people have to share fractionally. So that's why you would want to set up an entity. You wouldn't want to be, and you could be secured personally, you could be secured, but then remember that lightning bolt from the world that we don't see coming that hits you personally, then they get to ask you, what do you own? Oh, I have all these notes and they're secured. And now John Smith is the new owner of your security. So we would create a little lending company that you're lending out to these people. You would work there but not be the legal owner, and that way that company, in our example, Golden Mountain Lending, would put the lien against whatever the properties or the businesses that the people that are borrowing you.
Or be co-named on like the assignment of mortgage and the other documents to secure the asset then.
Absolutely, yes, sir.
Cool. A couple questions here about series LLCs, Kevin. How do you see a series LLC fit into this structure, or do you deal with those?
Yes, cell LLCs or series LLCs are very useful, particularly in the real estate business, to keep assets, notes or property or intellectual property, kind of separated business-wise, so you can have some that are successful, some that are just getting off the ground, some that are making money, some that are going to end up being write-offs, but have ease of management. So you coalesce them into one entity, so you don't have to have 20 bank accounts and 20 filings with the accountant and all that. They are problematic in some states. For instance, California says you can have a cell LLC, but each cell has to file their minimum $800 franchise tax. So they don't work in some circumstances, but in many jurisdictions they're great. They're easy for management. I would not use them usually on the lawsuit protection side unless it's only for notes. If you, it's more typical with actual real estate holdings. Notes, because they're fairly low liability, not zero, but low, we can pile them up in one company. It'd be fine.
Okay, that makes sense there. For somebody that's getting started here, it'll be the last question, and then we'll let you get going here. For someone who's kind of brand new, got a little bit of money, $50,000 or less, should they start first with opening a trust, or open an LLC first as they're starting to invest? What would you recommend?
Yeah, so even though I said earlier that you want to set up the trust and a privacy company contemporaneously or at the same time, so the trust is the original owner, that's not going to work for somebody at $50,000.
Right.
Yeah, I want to start driving my Aston Martin, but I had to start with a 1962 Volkswagen, Right. But we work our ways up to those cars and those business entities. So absolutely correct. You want to start with a company, and you probably want to start with an operating company, and then add a privacy company, even though you don't have, let's say the $2,000 to do the trust yet. Our lowest cost trust can be added when it's time. But again, do think about how much you have to lose. The bigger estates can take a wallop and cut out of the flesh and still survive. A smaller lawsuit will totally devastate the smaller client. So just do a little bit of meditation and see, maybe you can cut out a little bit more money earlier. But that would be my recommendation: an operating company first, then a privacy company. Get your name out of the public record. Even though you're the technical owner, remember I said you should not underestimate the power of privacy. So having a company without your name on it that owns low liability assets is very powerful, and then maybe the following year or whenever you're able, start to budget to add a trust on.
That's good advice, Kevin. That's awesome, man. I think I've answered Leon's question definitely for you. Yeah, Roman, the replay of this will be available. We'll be sending an email out with a replay for everybody here. Actually, I may get to it tonight, but otherwise it'll be first thing in the morning. Kevin, do you have another slide with your contact information, or do you want me to pull up your website where it's got it for you?
Great. It's Kevin at day-law, day-la.com. And that's our website also, so www.day-law.com. We've got a really good FAQ segment. Most of them, there's some that are not disjointed because they're actual questions that people have written in, and I write them the answer, and right before I press go, I go, oh, wow, I don't think those are on our FAQs yet. And so I take out their personal data and then throw those in there. So there's a lot of good information there, and of course we'll give free consultation to anybody that mentions Scott Carson's name, so you can get, a true picture with your circumstances what the little baby steps probably should be for your circumstances.
Yeah, totally, guys. I know we covered a lot of information tonight, but it's all about steps, and we all grow as investors. We gain, hopefully you're gaining assets as you're investing and growing wiser with the years and experience and the deal flow. It's important to really start looking at building things. I know when I first started off, I had an LLC. I was running everything through that LLC, and really not the smartest way of doing things is to have that one company that's running everything through versus having an operating company that's kind of running the day-to-day stuff, and then having an asset protection company, or like Kevin talked about in here, having well, what's the word I'm saying? Somebody protecting my assets and taking it off of public record and keeping it kind of high, because that's what it's all about. We all work hard. You're going to have people that sue you. You're going to have people get upset that for no reason. You could have done everything in the world and they're still get upset, or even deals go south. We all know that happens, and it's important to protect your assets and the money you work so hard for, and for your family and your loved ones as well. So we've got the website up here. You can see day-law.com is Kevin's website there. Once again, his phone number there is 858-755-6672. Just let him know. And if you talk to Kevin or Jacqueline, who does an amazing job there, you've got a really good one there in the office, because she's always very responsive about getting back to me with your answers, Kevin, for you. Just wanted to brag on her.
Thank you.
There, so.
I've got a bunch of good ones here. I've been lucky.
Kevin, let's see here. We got another thing here. Yeah, Leon, you definitely will enjoy talking with Kevin. Looks like we got a few people say, hey, I'll give him a phone call. Give him a phone call. Perfect. I'm going to actually, what I'll do too, Kevin, is I'll just send you everybody's information from the webinar as well too, so you can do a follow-up email out to everybody. And
great.
We'll go from there, bud. But thanks again, everybody, for great questions. Anything you want to wrap it up with, Kevin?
Thank you for having me on, Scott.
Anytime, buddy. I will talk to you tomorrow, and you're welcome, everybody. Chad, great. Christina, Bob, great offer, great info. Obviously, everybody, take the time. Kevin's the most knowledgeable asset protection attorney we've come across. They work very, very well with Laughlin Associates. I know quite a few guys are clients with Aaron Young and Laughlin Associates. There's a lot of information here. We went through the call, so make sure you get recorded. But the best thing you guys can all do for yourself, for your family, or somebody else, is literally pick up the phone and give Kevin a phone call. Schedule an appointment with him. Talk with him. He'll take the time to listen to you. What's your situation? Because everybody's situation is different, and there is no cookie cutter really plan for everybody. Everybody has a little different plan of action in what they do in their life and their real estate business. So take the time, and trust me, it'll be a conversation that you'll definitely appreciate later on. So, all right, everybody, have a great evening. Thanks again for joining us. Kevin, once again, thanks for taking time out of your busy evening. We'll talk to you tomorrow. Everybody, we'll see y'all guys at the top. Bye, everybody.